Hi folks, you're with Tacitus today, and we welcome Professor Stephen Baskerville of Patrick Henry College as our guest for the second time to talk about his latest and very highly recommended book, The New Politics of Sex, the Sexual Revolution, Civil Liberties and the Growth of Government Power. Cited as one of the foremost thinkers, writers and commentators in this all-important area, the application and operation of law as it relates to government power and the legal status of the citizen, Professor Baskerville speaks with great prescience as to how Western jurisprudence is changing insidiously before our very eyes, and in so doing, some may say, the political elites are stealing away at one of the key foundations of Western civilization: due legal process, innocent till proven guilty, unimpeachable rules of evidence, in independent apolitical courts of law. That is, and let's not mince words here, our civil liberties are at stake in this era of politicised globalisation. So let's jump straight into our conversation with Professor Baskerville. Well, Professor Baskerville, thank you very much. We're looking at Professor, as indicated in introduction, Professor Baskerville's most recent book, The New Politics of Sex, Civil Liberties and Government Power. And I don't think I've got the title completely correct there, but what we're looking at here is in effect, sexual politics and how sexual politics in the modern Me Too age, we could say, is affecting not only jurisprudence but social relations and the relationships between the state, the citizen, and the various groups and bodies that make up the civis. And that's really the scope. And in fact, the scope may even be wider than that Professor Baskerville is covering. So just on that basis, if you'd be so kind, Professor Baskerville, to just give a brief overview of what the book is about, and indeed some of the areas, and many of them contentious, that you're covering here, and then we can come back and have just a little discussion about some of those points.
Well, the most recent book, The New Politics of Sex, is an attempt to show the bigger picture, to tie together and connect the dots between the many aspects of sexual politics that are now bombarding our not only our culture, but our politics as well. In other words, many different aspects of sexual politics are treated often in isolation by different people who object to different features of them, which I can go into. But this book attempts to bring it all together, to show the larger pattern of what's going on. And it followed from my previous book. I saw that the things which I had observed in the divorce courts and the irregularities and the flagrant injustices and the lack of due process of law, but there was a larger pattern here. This wasn't just limited to the divorce courts. I still believe that that's the most, that that's the epicenter, that that's the cutting edge. But then many of these things are seen elsewhere in our politics. The false domestic violence accusations you see in divorce courts are mirrored with the false rape accusations that we now see in universities, or the rape accusations, sexual assault accusations, sexual harassment accusations that we see even in high politics, with for example, the nomination of Judge Kavanaugh to the Supreme Court, and the many accusations that have been made in this country, in Britain, in Australia, and in France, and throughout the Western world.
Okay. The sexuality angle that or sexual politics that you mention in the book, and there's many references to it. Do you believe that jurisprudence, as it was hitherto understood in the West, has itself been transformed into not legal practice and jurisprudence based on facts and evidence and sworn testimony that's being tested in a court of law, but rather it's moved into an area of ideology, where there's a degree of predetermination of guilt and innocence or culpability, of victimhood and oppression and so on, and this creates a level of prejudice that predetermines to a large extent legal outcomes. And not only that, but it actually reduces the burden of proof on the ideological oppressed victim or alleged victim, and increases the burden of proof on the alleged oppressor, all of which is determined ideologically. How do you see this as permeating through the the legal system in the context of civil liberties and indeed government power?
Well, the basic argument of the book is that nothing has done more to corrupt and debase the standards, of the legal standards, the standards of civil liberties and constitutional protections that we traditionally enjoy in the Anglophone world. Nothing has done more to debase those standards than the rise of sexual radicalism. In the U.S. and increasingly in Britain and other Anglophone countries, you hear this term, judicial activism, to suggest judges imposing their own opinions on the outcomes of especially cases that have political significance. I think this term underestimates grossly what is taking place here. I think, as you say, the courts throughout the Western world are permeated with political ideology. That the most pernicious and the most effective political ideology of all is the sexual ideology, which I describe in the book. And I also argue, I suggest, and I've seen nothing to contradict this, that the epicenter of this, that the font from which this is springing, is the divorce courts, that they are the cutting edge. They are the most corrupt sector of the judiciary in every country that I know of. They have introduced legal innovations, legal principles, lack of legal principles, innovations that have debased the law, debased due process protections, debased constitutional protections. All of this has taken place in the divorce courts, and it then has spread from there to the regular courts, to the other courts. So you simply cannot have, as many jurisprudentialists have said, have observed, you can't have two systems of law, one correct and one debased, operating next to one another. The bad law drives out the good law. If you try to have a system of law within the law that is based on corrupt principles, it's going to corrupt the rest of the legal system, and that's precisely what's happening.
Just in addition to that, there's the Western polities have built up over generations and over centuries, in some cases, a great deal of trust in some of the institutions, and independent courts of law being among them. So there's a belief by many people that they could go to a court of law to have a matter heard, have an independent judge and jury who would weigh the evidence and would reach a determination that the parties, in most instances, would accept as being an independent judgment based on the evidence. Now that trust, as it existed, is it being used in a I suppose an element of mass deceit here, where the very trust that the Western citizenry have in their institutions is being used and used up and being frittered away in this ideological fantasy land, and what we may end up with is not only a judicial system that doesn't function, if indeed we're not there already, but it will also involve the mass lack of trust in these very institutions. And it is the trust in these institutions that forms a very major part in our trust in our society and the human relationships and the relationship between government and the citizenry. Do you see this as being frittered away, and if it is, will it be recoverable?
Yes, well, it certainly is being frittered away. I mean, you're correct that there is a moral capital that has been built up in the legal system over that's taken centuries to build up. You're right, a legal system cannot work if it doesn't hold the trust of the people. I mean, the judiciary is the secular priesthood of our society. It's why judges wear robes, why we stand up when they enter the courtroom, why we address them as Your Honor, and why the courts administer the thou shalt nots, the 10 commandments of the American or English Bill of Rights. The courts cannot function. They don't have coercive power. They cannot function if people don't trust them, if people don't have respect for them. And you're right. They have this moral capital that has been built up, and it is being frittered away. We assume that when we hear of someone being prosecuted for a crime, we naturally assume that there's some justification in the prosecution. But in fact, this is not the case anymore. I mean, there's been numerous studies showing how, for example, in the U.S. at least, how the office of the grand jury has been basically eliminated for all practical purposes. The grand jury, which is supposed to keep a control over frivolous prosecutions and to prevent prosecutors from bringing frivolous cases just to harass citizens. Well, this is This doesn't exist anymore. It's an office that has essentially been abolished. What's striking in the present examples, in the case of these sexual accusations like domestic violence and rape and sexual assault, is how much of them take place in tribunals that are not real courts, and pseudo courts, and phony courts, and special courts, so-called. And this doesn't work. As the great English jurist A.V. Dicey said, the rule of law in criminal adjudication requires, quote, has to take place, quote, in the ordinary legal manner before the ordinary courts of the land. And yet we've created this whole archipelago of pseudo courts, family courts, juvenile courts, campus tribunals, courts which are domestic violence courts is another one. Special courts for special purposes, basically to make sure people are convicted or found guilty. And this is not the rule of law. This is not due process of law. And you can't do this in a free society.
Exactly. And just on that tribunal, or the tribunals, plural, I've noticed in places like, well, universities is a classic example, an accusation or an allegation can be made, often which is quite flimsy from what I've seen and lacking any real basis in facts. But it's enough in some instances to see the male student typically stood down, if not evicted from the college, on the spurious notion that the accuser has to be protected or in some way looked after, whilst the accused has no obvious or material legal rights. And when they're drawn before these tribunals, the members of the tribunal typically are activists who are themselves promoting the idea of arbitrary justice with a very lowered burden of proof to the accuser, but an increased burden of proof to those who are trying to deny the accusations. And so we've got a double situation here. Not only is the law being undermined or diluted or turned into some ideological plaything, but it's being populated with, in some cases, strident activists who are very much in keeping with these boutique type laws and boutique type courts. This means that the people who are appointing these what would you call them, these pretend jurists, what some may say are pretend jurists, that means they too must either be bowing to political pressure or indeed be part of this undermining of Western jurisprudence. Now, it could be just misguided thinking here, but I can't believe that many people could be misguided at the same time. So is there a purpose or underlying intent that you're able to sort of tease out of all these goings on, out from the miasma of all this undermined jurisprudence?
Well, this is precisely what I am trying to show in the book. I mean, the common denominator in all of these cases is radical ideology, radical sexual ideology, and this is another theme of the book. That this is what is dominating our politics. Whether it's by radical sexual ideology, I mean, first of all, radical feminism is the original form that it took. Increasingly, in recent years, it's become radical homosexualism, as some people call it, and nowadays transgenderism. These are all forms of political ideology. They're not just cultural phenomena. Their aim is they're political activists. And this is another dimension that I try to show in the book. It's not just the accusations that we see in the divorce courts and the universities and the militaries and other places, but also the rise of homosexualist politics and transgenderist politics. This too is part of the broad picture, and I argue that we have to look at all of this together as a whole, holistically, if you like. Because all of these things have in common is, again, an attempt at radical using sexuality as a political currency, using sexuality as a weapon or a tool to acquire political power.
This sexuality thing that you mentioned, it's in effect creating a new supra level of legal rights based on a person or individuals or groups alleged position on a ideological totem pole of oppressor and the oppressed. And thus, are we looking at an issue where new rights are being created well before there's an established order of law and system of law to deal with it, or are the new rights being created and they themselves, by their mere existence and their not being drawn into or not being part of the proper system of jurisprudence that we've known for decades or indeed centuries? Is it which do you believe it, or is it both? New rights coming in at one side whilst ideology is nibbling away at standards of jurisprudence on the other, or is it one or the other, do you think?
Well, this is another theme of the book, a major theme of the book, and that is this. I argue that there's a dynamic behind sexual politics that has not been understood. It's very difficult to understand. It's taken me a long time to understand it, and I'm still trying all the time. But the dynamic, or the dialectic, if you like, behind sexual politics runs something like this. First of all, in the one side of it involves sexual freedom, virtually unlimited sexual freedom. This is the liberal side, the side that says that sexual freedom is a good thing, that any inhibitions or prohibitions on sexuality is bad, that what we do in our own bedrooms is our own business, that just having sex out of wedlock, having sex with members of the same sex, having sex, breaking down gender, identifying ourselves as a different sex. I mean, all of these things are fine. There's nothing wrong with these things. This is the demand for, on the one hand, for unlimited sexual freedom. The other side of the dialectic is the authoritarian side. This is the side that says that we are the oppressed, and that then there is a that it's not it isn't limited to demanding unlimited to demanding sexual freedom. It also wants sexual control. It wants to substitute a new code of sexual conduct or sexual morality. In other words, having abolished the traditional Christian-based sexual morality, the prohibitions against fornication, adultery, cohabitation, divorce, homosexuality, and so forth, the sexual radicals want to substitute their own code of sexual morality, which involves crimes. And that's where the crimes of accusations of sexual harassment, sexual assault, rape, domestic violence, these sort of things come from. So the dialectic on the one hand is freedom, but the other side of the dialectic is authoritarianism. And it's very similar to the old cry that we heard in the French Revolution from the fanatic Antoine de Saint-Just, who said, "No freedom for the enemies of freedom." On the one hand, the French Revolution demanded unlimited freedom for the individual, but on the other hand, it led to the reign of terror. And I argue that it is a very similar dialectic that's operating here.
Absolutely. And we see Trotsky and Bukharin and those sort of people in the Bolshevik Revolution saying more or less the same thing, if not borrowing directly from the Jacobins, where the idea that if anyone opposed the ideas of the revolution, that they were automatically the enemies of the revolution. When they were the enemies, they thus had no rights. Once they had no rights, they thus could be dispensed with, or even outright murdered in the case of the Bolshevik Revolution, and that was not a matter for concern. In fact, that they treated it as a matter for rejoicing, even, which indeed the Jacobins did. And I'm thinking now of some of the firebrand speeches from Mirabeau and those sort of people in the French Revolution. They're talking up these very sort of views. Let's do another session on this, if we may, Professor Baskerville, because once we've identified, I think, reasonably coherently and succinctly what some of the challenges and problems may be, but what are we going to do about, or rather, what can the citizenry do? How can the citizenry express their concern through legitimate and legal means? And so, if you would be so kind to return to this platform, and we'll talk some more and address those very issues about having identified these things, what can we now do, and how can we take this discussion and debate further? But the key here for everybody is to and I'll leave the link below, as well as some of the excellent reviews. Professor Baskerville's book, The New Politics of Sex, Civil Liberties and Government Power. It's available on Amazon, and I'll put the link below, along with other articles and some excellent articles that have been written about the book, including Whistleblower Magazine and so on. So have a look at that book. It's a must-read, and when you've digested that, we'll have another chapter for you on this platform, and we can talk some more about it. Professor Baskerville, thank you very much.
My pleasure. Thank you. I look forward to it.